Donald Trump made a "my lips are sealed" gesture outside his civil fraud trial today, but he was anything but tight-lipped on the stand.
Extraordinary tension inside that courtroom, with Donald Trump really pushing and pushing and pushing the judge.
Trump sure looked ready for a fight as he glared at the camera. He clashed with Judge Arthur Engoron from the moment he took the stand, giving long speeches instead of yes and no answers. "This is a very, very unfair trial. Very," Trump complained. "Control your client," the judge told Trump's attorneys. "If you can't, I will." He even snapped at lawyer Alina Habba, telling her to sit down when she insisted maybe he should listen to Trump's long-winded rants. She hit back outside the courthouse.
I was told to sit down today. I was yelled at, and I've had a judge who is unhinged slamming a table. Let me be very clear. I don't tolerate that in my life. I'm not going to tolerate it here.
Hey, everyone, listen up. This is explosive. What just happened in that Manhattan courtroom is absolutely shocking. For years, Donald Trump has built a powerful myth that he walks into any courtroom and dominates, that judges fear him, and that he bends the system to his will. But today, that entire myth went up in flames right before our eyes. Millions watched the raw, unfiltered collision between fantasy and reality. The moment Judge Arthur Engoron looked down from the bench, he made one thing crystal clear. The rules of this courtroom apply to everyone, including Donald Trump. No mercy, no exceptions. What followed was not dominance. It was not control. It was a 6-minute spiral of pure defiance. Trump took the stand, ranted, gave long political speeches instead of simple answers, and kept pushing the judge harder and harder until the courtroom finally hit its breaking point. Judge Engoron turned to Trump's own lawyer and delivered the hammer: control your client. Then he cut Trump off completely and slammed the gavel down on the entire spectacle. So what happens when the myth dies on live television?
The judge in this case, Judge Engoron, however, was visibly frustrated with Trump repeatedly during the course of his testimony, urging Trump's lawyers to get their client, to get the witness in line, to say yes or no to yes or no questions. And at one point, Judge Engoron warned Trump's legal team that if Trump did not change his conduct in the courtroom in terms of how he answered questions, he would have, quote, negative inferences when it came to the scope of the penalty in this ongoing civil case.
The footage exists, the transcript exists, and what it shows is far more serious than just a bad day for a defendant. It captures the exact moment when Trump's courtroom performance slammed into the hard limits of reality and the performance lost. Let me set the stage clearly. This was the closing argument phase of New York's high-stakes civil fraud trial. Judge Engoron had already ruled that Trump committed fraud by systematically inflating his asset values by up to $2.2 billion, turning the genius businessman into what looked more like a billionaire used car salesman on financial statements. The case struck at the heart of his empire: years of deceiving banks and insurers to secure better loans and insurance deals. What remained was the massive penalty and whether he could still run his businesses in New York.
A New York judge now ruling that former President Donald Trump committed fraud and lied about his net worth for years. And according to the court documents to send to us, Mr. Trump apparently, according to this judge, lied to banks and insurers, exaggerating his net worth to the tune of something like billions of dollars. This is all ahead of a civil trial that is set to begin on Monday. I want to get right to Tom Winter. Explain what the judge is saying here and its significance.
Right. So the judge is basically saying that the Attorney General for the state of New York, Letitia James, came forward with a civil complaint last year and said that the former president, through his businesses and his personal financial representations, committed fraud by overstating his personal wealth and the wealth of his properties.
The stakes were enormous, not just financially, but existentially for Donald Trump. This trial went far beyond money. It struck at the very heart of his carefully cultivated identity, the self-proclaimed genius businessman whose net worth is exactly what he says it is. For years, Trump has branded himself as the ultimate deal maker who always tells the truth about his wealth. That's why he demanded to deliver his own closing argument. He didn't want his lawyers speaking for him. He wanted to stand directly before the judge and make his case in his own unfiltered words, believing only he could effectively defend the empire he built. Such a request is highly unusual. In civil trials, defendants almost never give their own closing statements. That is the role of attorneys. But Trump is not a typical defendant. His strategy has repeatedly blurred the line between serious courtroom advocacy and pure political theater.
Fireworks in the courtroom. Donald Trump delivering his own closing argument in his Manhattan civil fraud trial today, facing the prospect of losing control of his namesake company and a massive civil penalty. Mr. Trump briefly took matters into his own hands, declaring himself an innocent man, delivering a nearly 5-minute speech, largely grievances against the New York Attorney General and the judge overseeing the case, whom he accused of having his own agenda. All that forcing Judge Arthur Engoron, who previously resisted granting the former president permission to speak in closings, to call on Mr. Trump's attorneys to, quote, control their client.
They don't have any evidence against us. Millions and millions of pages, years of litigation, and all politically motivated.
The surreal scene in court today playing out just hours after police responded to a bomb threat at Judge Engoron's home.
Judge Arthur Engoron was not unreasonable. He was not hostile from the start. In fact, he was willing to consider letting Donald Trump deliver his own closing argument, something highly unusual in a civil trial. He didn't reject the request outright. He gave Trump a genuine opportunity, the same kind of opportunity any other defendant would receive under the same circumstances. But here's where it gets revealing. The judge imposed one simple standard condition, the exact same condition that applies to every single closing argument in every courtroom across America. Trump's legal team had to promise that their client would stick strictly to the law and the evidence already presented during the trial. No campaign speeches, no political rants, no introduction of new material that hadn't been properly submitted, just the facts of the case and the relevant legal standards. Think about what that condition really means. It wasn't special treatment. It wasn't targeting Trump. It was the bare minimum required to maintain the integrity and order of a courtroom. Any judge in any civil case would demand the same thing. And then came the moment that told us everything we needed to know about this defense strategy. Trump's own lawyers, officers of the court, bound by ethical rules of candor and professionalism, refused to make that promise. They would not assure the judge that their client would follow basic courtroom procedure if given the chance to speak. They knew exactly what Trump was going to do. They knew he could not or would not contain himself within the boundaries the judge had set. Rather than give their word and risk watching him break it live on the record, they simply refused to give their word at all. Let that sink in. The attorneys representing the former president of the United States in one of the most high-profile civil fraud cases in New York history could not guarantee that their client would behave like a normal litigant. That single refusal spoke louder than any closing argument ever could. As a direct result, Judge Engoron denied the request for Trump to deliver a formal closing statement. The lawyers would handle the closings, exactly as happens in virtually every civil trial in this country. That should have been the end of it. The traditional closing arguments proceeded. Legal points were made. The case moved forward in an orderly fashion. But Trump's team wasn't finished. Attorney Christopher Kise rose and asked the judge once more, a second bite at the apple that had already been denied. It was a procedural Hail Mary, and it forced the judge into the awkward position of having to engage directly with the defendant about what he would and would not be permitted to say. Judge Engoron turned to Trump himself and asked him plainly, would he agree to follow the standard guidelines that apply to every closing argument in every courtroom in America? Trump's response was immediate. And it was not an answer. Instead of saying yes, he launched straight into a tirade. He declared himself an innocent man being persecuted. He called the entire proceeding a fraud on him. He attacked the New York Attorney General. He complained about political witch hunts. And then, in one of the most striking moments of condescension you will ever see in an American courtroom, he looked directly at the judge wearing the robe and said the words that will follow him for the rest of these proceedings. I know this is boring to you. Sit with that sentence. A sitting judge presiding over a complex, multi-week civil trial involving billions of dollars in alleged fraud, being told to his face that the proceedings were boring to the defendant, as if the judge were a distracted student in a lecture hall rather than the judicial officer exercising the full authority of the state of New York. The condescension was personal. The dismissal was direct. And it was aimed squarely at the one person in that room who had the power to end the spectacle. Judge Engoron did not debate him. He did not engage with the substance of the rant. He did not try to reason with the defendant who had just proven he had no intention of being reasonable. Instead, he turned calmly to Trump's attorney and delivered a directive that every lawyer in that courtroom immediately understood. Control your client. 4 simple words, but they carried enormous weight. They told the entire room that the judge had identified behavior that had crossed the line of acceptable courtroom conduct, and he was placing the responsibility where it belonged, on the shoulders of the attorney whose professional duty it was to manage the client. Then the judge imposed a hard limit, 1 minute remaining before the court would break for lunch. 1 minute for Trump to wrap up whatever he thought he was accomplishing. When that minute expired, Judge Engoron cut him off, not gently, not with hesitation, and recessed the court. The proceeding ended not because the judge was unfair, but because the defendant had made it impossible to continue without abandoning the basic standards of order and respect that American courtrooms require to function.
But then after all of his attorneys finished their closing arguments, Chris Kice's lead attorney said to the judge, "Can the former president please speak?" The judge gave him the remaining 5 or 6 minutes of the day where he said, you can talk, but you have to work within these ground rules, which is what talk about the evidence and talk about the law. And Trump didn't. He proclaimed that he was an innocent man, that he was being persecuted. He said, this was a political witch hunt. What's happened here, sir, is a fraud on me. And he continued to go on and to attack the investigation. So the judge gave him a cue that he had 1 minute left. And Trump said to the judge, you have your own agenda. I understand that. Judge saying, Mr. Kice, please control your client.
Trump's response revealed everything in real time. Instead of addressing the judge's direct question about following basic rules, he pivoted instantly into grievance mode. He framed himself as the victim of a vast conspiracy. He dismissed the entire legal process as illegitimate. He treated the courtroom not as a place of justice, but as another stage for his familiar narrative of persecution. This was not improvisation under pressure. This was a deliberate choice. A man who has built his entire public persona around strength and dominance refused to show even a momentary deference to the institutional authority standing right in front of him. By refusing to engage with the question on its own terms, Trump effectively told the court, your rules do not apply to me.
Judge Engoron's calm but firm response was not an overreaction. It was the minimum necessary to preserve the dignity of the proceeding. When a defendant openly signals that he will not abide by the most fundamental norms of courtroom behavior, the judge has a duty to act. Allowing the spectacle to continue unchecked would have undermined not just that single trial, but the credibility of the judicial process itself. What makes this moment particularly striking is how it exposed the gap between Trump's self-image and the reality of legal accountability. For years, he has projected an aura of total control, the dealmaker who always wins, the fighter who never backs down. Yet here, under oath and under scrutiny, that projection cracked.
The longer he spoke, the more he demonstrated that he could not operate within the constraints that every other litigant must accept. This wasn't mere frustration. It was a fundamental incompatibility. Courtrooms are built on precision, on evidence, on measured argument. They reward preparation and restraint. Trump's style, fluid, emotional, expansive, and relentlessly personal, is the exact opposite. It thrives in arenas where there are no time limits, no rules of evidence, and no neutral arbiter with the power to cut the microphone. By telling the judge the proceedings were boring to him, Trump wasn't just being rude. He was revealing a deeper contempt for the slow, methodical nature of judicial work. To him, the careful examination of financial statements, the application of decades-old legal precedents, and the methodical weighing of evidence were somehow beneath his attention. That single remark crystallized the arrogance at the center of his approach to the law. The judge's decision to impose a strict 1-minute limit and then recess the court was not theatrical. It was procedural hygiene. American courts have functioned for over 2 centuries precisely because judges are willing to enforce boundaries when participants refuse to respect them. In that moment, Judge Engoron was doing what judges have always done when faced with a defendant who treats the courtroom like a campaign rally. He reasserted order. Consider the broader implications inside that room. Every attorney present, every court officer, every journalist watching understood what had just occurred. A former president, a man who once held the highest office in the land, had to be told by his own lawyer's judge to be controlled. The power dynamic was unmistakable. No matter how wealthy, how famous, or how politically powerful a defendant may be, once inside those walls, they are subject to the authority of the court. This confrontation also highlighted the difficult position of Trump's legal team. They are caught between their ethical obligations as officers of the court and their clients' unshakable instincts. Their inability to promise compliance earlier was not weakness, it was realism. They knew their client, they knew the risks. And when the moment came, they watched the inevitable unfold. Yet even in that tension, something important happened. The legal system demonstrated that it still possesses the internal mechanisms to check even the most defiant participant. The rules held. The gavel came down. The proceeding paused rather than descending into chaos. That is not a small victory in an era when so many institutions feel fragile. What we saw was not just one man losing his temper. It was a live demonstration of the eternal tension between individual charisma and institutional restraint. Charisma wants the spotlight. Institutions want consistency. Charisma wants exceptions. Institutions demand equality under the law. Charisma performs. Institutions deliberate. In that Manhattan courtroom, the institution reminded everyone present and everyone watching that it still has teeth. It can say enough. It can enforce time limits. It can demand basic respect. And when those demands are ignored, it can simply stop the show. This single episode strips away the layers of political mythology and leaves us with a clearer picture. Donald Trump approaches the legal system the same way he approaches politics, as something to be dominated rather than respected. When domination fails, the response is not reflection or adjustment, but escalation and externalization of blame. The deeper tragedy is what this reveals about the erosion of shared norms. Once upon a time, even the most powerful figures in America understood that entering a courtroom meant accepting its authority. Today, we see a prominent defendant who views that acceptance itself as weakness. Judge Engoron's handling of the moment was a quiet but powerful reaffirmation of an old principle. No one is above the law, and no one is above the rules that make the law possible. The confrontation ended not with a bang, but with the firm procedural finality of a gavel. In that sound was the message every courtroom must occasionally send. The performance, no matter how compelling, must yield to the process.
They don't have any facts. They don't have any evidence against us. Millions and millions of pages, years of litigation, and all politically motivated. She campaigned on "I will get Trump." If you've ever seen any of her clips, they're horrible clips, actually. The anger, she's got serious Trump derangement syndrome. There's no question about it. Letitia James, the corrupt Attorney General of New York. So we've proven our case. There's not one witness against us other than one person who is a deranged. He's got a lot of problems. He's a man who's been convicted of lying. He's a felon, convicted felon, and not a good person. But that's their only witness, and he's now crashed and burned. They have no witnesses. And by the way, that witness took back everything that he said. He took back everything he said in court, took it all back. So they have no case. It's a shame that a thing like this is able to happen. Businesses leave New York. She went after Exxon, and they decided to move to Texas. And hundreds of millions of dollars they pay in taxes. I paid over $300 million of taxes over the last number of years. $300 million. And they don't recognize that. They don't recognize anything. So think of it, not one witness, millions of pages of document, years of this nonsense, and now it goes on. And one other factor, we won this case already in the Court of Appeals. The Court of Appeals voted in favor of us. But this judge has been very, very slow to accept that opinion because that's not the opinion that he wants. But we won in the Court of Appeals. That's the boss of this judge. He has to know that. And it was a conclusive victory, statute of limitations and other things. And that case has already been won. So that's the story. And I thought we'd come down to 40 Wall Street, which is a great building.
And what did Trump do the moment the gavel came down and court recessed for lunch? He didn't stay. He didn't sit through the afternoon session like any ordinary defendant would. Instead, he left the courthouse entirely and walked straight into a press conference he completely controlled, inside a building he owns, surrounded by cameras and supporters who would never cut him off. There, the same grievances poured out again, only this time without any judicial restraint. He attacked the judge, attacked Attorney General Letitia James, called the entire case a witch hunt and election interference, and insisted he had already won on appeal. The courtroom confrontation didn't end. It simply moved to friendlier territory. This sequence is now unmistakably clear. When the rules of the courtroom impose limits, Trump immediately seeks a stage where there are no limits. When a judge demands order, he finds a microphone that will never say time's up. The pattern is consistent. Inside the institution, he faces accountability. Outside it, he faces applause. This is not strategy born of the moment. It is a deliberate, repeated choice that has defined his entire relationship with the legal system. Trump does not treat courtrooms as neutral forums for resolving disputes. He treats them as political battlegrounds where victory means dominating the narrative rather than respecting the process. When that domination fails, the response is not adaptation, it is relocation and escalation. The implications stretch far beyond this single trial. Across multiple cases, we have seen the same playbook. Label every adverse ruling as politically motivated. Attack the judge personally. Then rally supporters by turning legal setbacks into fundraising and campaign fuel. Even judges he appointed to the Supreme Court have not been spared when they ruled against him. This approach sends a dangerous signal to the entire judiciary. Loyalty matters more than independence. American legal institutions were never designed to withstand this level of sustained, high-profile defiance. They rely on a foundation of shared norms, that participants will accept the authority of the court, that attorneys will restrain their clients, and that even the most powerful defendants will show basic respect for the process. When those norms erode, the system must work harder, and public confidence inevitably declines. What happened after the recess was more than optics. It was a vivid demonstration of how a defendant can reject a courtroom while still claiming to respect the rule of law. Trump didn't quietly accept a judge's decision and prepare for the next phase. He reframed the entire day as proof of persecution, transforming procedural defeat into political martyrdom. This tactic resonates with his base, but it carries a heavy cost for the country. Every time a prominent figure successfully turns judicial accountability into a grievance performance, it becomes slightly easier for the next defendant to try the same thing. The informal mechanisms that keep courtrooms functioning, respect, restraint, and acceptance of adverse rulings, begin to weaken. Defenders will argue that high-profile cases deserve skepticism and that powerful people sometimes face unfair pressure. There is truth in that. But those arguments do not explain away the specifics here. Skipping court to hold a victory lap press conference is not legitimate frustration. It is prioritizing political messaging over legal obligation. Framing every loss as a conspiracy is not reasonable criticism. It is systematic undermining of institutional legitimacy. Judge Engoron's courtroom that day represented something important. The idea that no one, regardless of past office or current influence, gets to rewrite the rules in real time. The legal system still possesses the ability to say no and make it stick, at least within its own walls. Yet the bigger question remains open. Can these individual judicial pushbacks accumulate into meaningful deterrence? Or will the cycle of confrontation, walkout, and counterattack continue indefinitely, each time chipping away at the cultural authority that makes the rule of law possible? What we witnessed in full today, the demand to speak, the refusal to follow basic guidelines, the recess, and the immediate pivot to a controlled press conference is more than courtroom drama. It is a stress test for whether American institutions can still enforce basic standards when the most visible defendant in the nation refuses to accept them. The performance is powerful, the cameras love it, the base rewards it, but the institution still held the line for the length of that session. Whether it can continue holding that line across the many confrontations still to come will help define the future of accountability in this country. The gavel eventually falls. The question is whether the country is still willing to listen when it does.